Hello, my name is Allison Greenberg. I'm here today to discuss some of the laws that may provide you with protection in the workplace, whether you're in active treatment for cancer or in remission. What does the law say? Well, there are laws that protect people with disabilities. Cancer is recognized as a disability, and even if you're in remission from cancer, you may still have protection from discrimination. An employer's perception of a disability can give rise to protection for the employee or even a job applicant. Fortunately, there are federal, state, and local laws that offer protections for people with cancer and those who are in remission. I will talk about some of these laws. In particular, I will address federal laws relating to discrimination, permitted leave, employee benefits, and COVID-19. I'll also touch on New York State human rights law and the New York City human rights law. There may be other local laws that apply to you depending on where you work and where your employer is headquartered. You may have protection against discrimination that is latent and discrimination that is outright and offensive, where a hostile work environment is created due to you having cancer or being in remission from cancer. Even if you're applying for a job and therefore are not yet employed, you have protections against discrimination. In terms of federal law, there's the Americans with Disabilities Act, known as the ADA. The ADA applies to private employers with 15 or more employees. The ADA also applies to state and local government employers, employment agencies, and labor unions. When it comes to federal protections against disability discrimination in the workplace, there is also a law known as the Rehabilitation Act, which covers federal contractors and programs receiving federal funds. Importantly, the ADA provides a very short timeline within which you need to pursue your rights. And this is called filing a charge with the EEOC. Technically, you have 180 days from the discriminatory behavior. That may be your termination, that may be 180 days from the beginning of harassing behavior that relates to your disability. And if you have rights under state law, that may extend the deadline to 300 days. But either way, that deadline is very important. Unlike the ADA, the New York State human rights law applies no matter the size of the employer. There is no employee minimum in order to have protection under that law. And under the New York City human rights law, employers with at least 4 employees are covered by the law. Whether these laws apply to your particular situation will depend on multiple factors, and you should seek guidance from a lawyer to determine what laws might cover your situation. Now, with respect to discrimination and wrongful treatment, there are federal, state, and city laws that provide protection. And the wrongful treatment could be behavior that is outright harassment due to your disability. And this would fall under the category of a hostile work environment based on discrimination. For example, a supervisor makes multiple derogatory comments about your changed appearance due to your cancer treatment. This could constitute a hostile work environment based on discrimination against disability. But sometimes the discriminatory behavior is not outwardly hostile, but the employer takes an adverse action due to a protected characteristic. It could be that you're laid off shortly after you disclose you have cancer, and you're the only person who's laid off. That's suspicious, and you may have a claim under the ADA. But ultimately, either way, you're going to need to show that the discriminatory intent was the motivation for your termination. Causation is important. Another area of the law that relates to disability discrimination is known as reasonable accommodation. This is an important protection, and it's going to be covered in a separate video. And another area of the law that is covered with respect to disability discrimination under the ADA under New York State's human rights law and under the New York City human rights law is known as protection from retaliation. The law protects you when you've engaged in protected activity in response to certain behavior. And the law varies under federal, state, and city law. In general, if your employer terminates you because you filed a complaint with the EEOC about how you were treated in connection with having cancer, and you've alleged that you were terminated because you had filed this complaint, that might be retaliatory behavior under the law. What does retaliation look like under the ADA? The employee had to have engaged in a protected activity. The employer was aware of the protected activity. An adverse action was taken against the employee, and there was a causal connection between the alleged adverse action and the protected activity. So this is very heavy on legal terms, and I can break it down a bit, but this is certainly another area where it makes sense to seek guidance from the Cancer Advocacy Project or a lawyer directly or other legal support. So what is a protected activity? It varies from federal law to state and city law. In general, a protected activity is when someone makes a formal complaint, whether filing a complaint with a court or filing a charge with the EEOC, or opposing behavior that one believes is discriminatory. That may also be protected activity. On the other hand, if you make a complaint to your supervisor when you're sitting in the lunchroom about behavior that you think is discriminatory, that probably won't be considered protected activity. It will probably be scrutinized more closely by a judge. Putting a complaint in writing, including email, is important because this provides evidence that the employer was aware of the complaint, and knowledge is a component of this law. If, on the other hand, you allege that you told someone you felt you were being discriminated against, and then you thought you were retaliated for that, well, then it's your word versus his, and that probably won't rise to the level of protected activity, and also probably won't be very reliable in terms of evidence. Look, from a practical perspective, people, of course, resist putting things in writing, sending emails to the employer, or otherwise complaining in writing, because you don't want to look like a troublemaker. You don't want to rock the boat. But you may have to decide whether it's better to make things more formal so that you'll have such a claim if you need it, or you may decide that you would rather take your chance and not rock the boat. And ultimately, again, I advise that you seek legal guidance about how to handle this type of situation. Another area of the law is the Family and Medical Leave Act, also known as the FMLA. The FMLA is a law that provides employees with up to 12 weeks of unpaid leave per year. It's protected leave, meaning your job should be protected under most circumstances. It requires that the employer maintain your group health benefits during your approved leave. And the FMLA protects against retaliation for taking that leave, and it also protects you from interference with that leave benefit. To be eligible for the FMLA, you need to have been employed with a company for at least 12 months. You need to have worked for the employer for at least, 1,250 hours during that time. And the employer must have had at least 50 employees. And shifting to another body of law, there is New York State and New York City paid leave laws that now exist. And you may have protection under the New York City and New York State paid leave laws. This will depend on where you work and where your employer is headquartered. Unlike the FMLA, under New York State and New York City paid leave laws, you have the right to paid leave. And you may also have protections against retaliation and protection from interference with these paid leave laws. And yet another body of law that may protect your rights with respect to cancer is the Employment Retirement Income Security Act, known as ERISA. ERISA is a federal law. It provides protection for employee benefits, such as pensions, life insurance, and health benefits. And ERISA may apply where a person is terminated for improper reasons and denied those benefits. So if an employer interferes with your receipt of a retirement package, you're denied those benefits, then you may have protection under ERISA. Here's an example of where ERISA may apply. Susan worked for a company for 25 years. She's on the verge of vesting in the company's executive retirement plan. She starts cancer treatment and she's out of the office twice a week, once a month with a doctor's note, but she's suddenly terminated and she's not afforded the opportunity to pursue the retirement benefit. She may have a claim under ERISA. So this is yet another protection you may have under the law if you have cancer or if you're in remission from cancer. And now I'm going to move on to a final area, a final topic area, COVID-19 related laws. We're living in a pandemic, and in the last year, laws have been passed. And as we speak, laws are changing. People are being vaccinated, and that is changing how people feel about working in an office and whether employers are bringing people back. So the EEOC has examined the impact of COVID-19 on people who are already vulnerable in the workplace, such as people who have cancer, people who face discrimination in the workplace. The EEOC's guidance about COVID-19 and the intersection with anti-discrimination laws is on its website and will probably change as time goes on and as more people are vaccinated. There is also what's known as OSHA. OSHA is a protection for people when it comes to safety in the workplace. You may have protection if you believe that your employer is violating COVID-19 related workplace safety laws. And let's say you've told your employer that you believe they're violating the law, or you have told your employer that you've made a complaint to a local government office that regulates health and safety, and you're terminated. Well, you may be a whistleblower under OSHA. That is a very short deadline. You need to file that complaint within 30 days. So if something like that happens, if you think your employer is violating workplace safety laws and you're concerned about how that impacts you and your fellow workers, you need to look at the OSHA law very promptly and again, consult a lawyer promptly. And then finally, for today, there's the Families First Coronavirus Response Act, which was passed last year and was renewed this year in 2021. This is a federal law requiring certain employers to provide paid sick leave and expanded family and medical leave to allow the employee to care for a child whose school or place of care is closed due to COVID-19. So that is the conclusion of my overview. I hope it was helpful. Thank you.